Yeah, we
Go, boy. You go.
Lamont, you like that?
Yes, I like that one.
Throw up both your hands. Okay.
Throw up both your hands.
Yeah.
Oh yeah, throw up both your hands.
Oh, okay. Okay. You stay muted, Mr. Bailey, please.
Yeah, y'all
don't
can
stop.
jump in the courtroom, but I can't.
Beg your pardon?
Nothing.
Oh, I didn't think so. Okay.
Oh, I ain't think so. I'm just gonna repeat what you said. You said throw up both your hands.
No, I didn't say that, sir. That was not me.
I was about to throw up both my hands. That's all.
All right.
I was about to.
There's John Holler,
Okay,
the
there's
attorney. Is the attorney here?
Yeah, Mr. Holler, your client, and okay.
I don't see him.
What kind of? You must have a
sound like a man.
screen.
You sound like a man there.
Oh, there he is. Yeah, John, we're back.
All right, Mr. Holly, you ready?
I'm ready.
All right, Mr. Bailey, I'm calling your case 24-0556-2701, People versus Marvin Bailey.
Good morning, Your Honor. Cal Nazier for the people.
Where's Nitro camera not on?
Oh, yeah,
I don't see him.
Girl, okay.
Hold on, sir.
Yeah.
Mr. Holly, appearance.
John J. Holler on behalf of Mr. Marvin Bailey, who's joined us by the Zoom technology.
All right, Mr. Bailey, I need your name, sir.
Marvin Bailey.
All right, good morning. All right, Mr. Nazier, any offers here?
Judge, Mr. Holler emailed me some information yesterday to give me more to look at and read, and I've had email communication with him. Currently, the offer is no reduced plea.
All right, how you want to proceed today, Mr. Holler?
Well, the offer is no reduced plea and 2 years of probation. Isn't that right, Mr. Najjar?
Correct.
Okay.
With other conditions, that's correct.
Okay, with some other conditions to be determined. If we can do a situation where my client can pay in lieu of community service, something like that, we can take a plea.
Before we even press play, let's set the stage. Today's case takes us to a courtroom in Detroit, Michigan, where a man charged with carrying a concealed firearm without a license is handed what many defendants would consider a gift: a felony plea deal with probation instead of prison. Under Michigan law, MCL 750.227, carrying a concealed weapon without proper licensing is no small matter. It carries serious consequences, up to 5 years behind bars. But here's where things spiral. Instead of quietly accepting a reduced sentence, our defendant decides this is the moment to flex confidence, attitude, and a little bit of internet law school bravado. What unfolds is a masterclass in how to sabotage your own plea deal in real time. Watch closely because the tone shifts fast. What starts as routine plea negotiations quickly turns into courtroom tension, judicial warnings, and a judge who is absolutely not in the mood for disrespect.
His camera's off.
I'm here.
All right, you understand what the prosecutor's offer is, sir?
No, I don't.
Mr. Nazier.
I don't even see the prosecutor. Who is the prosecutor? His camera's not on.
What does that have to do with it, Judge?
The offer that we've discussed is to plead guilty to carrying a concealed weapon without a license to do so, which is a felony. 2 years, a sentence agreement of 2 years of probation, and you will have the opportunity to pay.
And just like that, before we even reach formal introductions, we already have chaos. That throw up both your hands comment? Whether it was meant as a joke, trash talk, or something else entirely, this is not how you enter a felony proceeding. Courtrooms operate on structure, hierarchy, and respect. Especially over Zoom, where microphones catch everything and there's no physical courtroom pressure to keep people in check. The defendant doesn't yet realize something crucial. Judges have enormous discretion when it comes to contempt. A flippant comment can escalate quickly. What might feel like just talking can legally qualify as disruptive conduct. And when you're already facing a weapons charge, adding a contempt finding to the mix is like pouring gasoline on a fire you're trying to put out.
Hey.
Okay.
Mr. Bailey, watch your mouth, sir.
Man, okay.
Here's what's gonna happen, Mr. Bailey. If you keep it up, I'm gonna bring you into the courtroom and take you into custody and find you in contempt. Settle down,
All
sir.
right, bro. All right.
That's the judge, it's not your bro.
All right, sorry about that. Sorry about that, Judge.
All right, go ahead, Mr. Holler.
Okay, thank you, Your Honor. And at the time of sentencing, the court can determine that that Mr. Bailey would be able to pay a certain sum of money in lieu of community service if he so chose. So it would be like an either or type of thing. So that the court would determine an appropriate amount of community service versus an appropriate amount of additional costs or fines, however we want to characterize that he could pay at his election. He would be on probation for 2 years.
All right. Mr. Bailey, you understand what that offer is, sir?
Yes.
All right, you waive your right. Now you understand you have a right to have a preliminary examination, sir?
Yeah.
You waiving your right to have a preliminary examination today?
Yes, sir.
Anybody threaten you or force you to get you to waive your examination right today?
No, don't nobody threaten me.
All right, court's going to accept the waiver. Mr. Bailey will automatically be bound over. Mr. Holler, as it relates to the arraignment, he's standing mute and waives the formal reading of the information.
I do.
Court's going to enter not guilty plea today.
Hey, can I ask?
Notice what just happened. Immediate denial. This is a subtle but important psychological shift. Instead of clarifying or apologizing, he distances himself from the comment entirely. That might work in casual conversation. It does not work well in a courtroom where everything is recorded. Judges are trained to read tone, pacing, and credibility. When someone denies something that was just plainly heard, it can chip away at their perceived reliability. And credibility matters immensely during plea negotiations. The entire system is built on trust. Trust that you understand the charge, trust that you admit to what happened, and trust that you are taking responsibility.
Go ahead, sir.
Can I ask a question?
Go ahead, sir.
After we do this plea, like after I finish my probation and complete everything, like, would I still be able to get my license? Because I like to have my documents intact, in order, and everything.
All right.
I know I was wrong for the case and everything, but like, would I be able to do that?
You have to talk to Mr. Holler about that. He can give you the legal advice.
Okay.
All right, please raise your right hand. You freeze. All right. Do you solemnly swear or affirm the testimony you're about to give today will be the truth?
Yeah.
Yes?
Yes.
Yes.
All right, you can put your hand down. You understand if I accept the plea from you today, sir, you give up or you waive? First of all, you understand that the maximum penalty I can impose if I accept a guilty plea can be up to 5 years in prison.
Yeah.
You understand if I accept the plea from you, sir, you give up or you waive certain constitutional rights.
Yeah.
You understand you waive your right to have a trial by judge or jury.
Yes, sir.
You have your right to remain silent without that silence being used against you.
Understood.
Is that a yes?
Yes, sir.
You have your right to be presumed innocent until proven guilty beyond a reasonable doubt.
I'm gonna say yes to that, but I was already. I'm guilty. Yeah, though, because they already said I was guilty, man.
2 years of probation on a felony concealed weapons charge is not a bad outcome. In fact, considering the statutory maximum of 5 years in prison under Michigan law, this is what many defense attorneys would call a manageable resolution. Probation means no prison time up front. It means compliance, supervision, conditions, yes, but it also means freedom. This is the moment where most defendants nod quietly and follow counsel's lead. Instead, watch what happens. Because instead of treating this like a lifeline, he's about to treat it like a debate stage. And when defendants start arguing technicalities without fully understanding the law, especially firearm statutes, things tend to unravel fast.
Sir, what you understand is you're giving up certain rights. You have certain constitutional rights. In order to take a plea, you have to give up or waive those rights. That's what
Yeah, though. Yeah.
All right, you understand that you waive your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yeah.
Is that a yes?
Yes.
Anybody threaten you or force you to get your plea guilty?
No.
Anybody promise you anything beyond what the
No.
prosecutors? Anybody promise you anything beyond what the prosecutor's office has offered you to get your plea guilty?
No.
All right. Anybody? Mr. Nature, date, time, location, factual basis, please.
Thank you, Your Honor. Mr. Bailey, on February 5th, 2024, in the area of Binder Street in the city of Detroit.
It's Binder. Binder.
Binder Street in the city of Detroit. At some point, did you have contact with the police that day? At some point, did you have contact with the police that day?
I ain't had no contact with the police. They contacted me.
Right. Okay. You were arrested that day?
Yeah.
Okay. So prior to that, at some point prior to that, did you have a handgun, a pistol?
You said, did I have a handgun, a pistol?
Yeah.
Yeah, I had that big Glocky on me.
And was it concealed in some fashion at some point?
I had a 30 round hanging out the clip. I had a 30 round hanging out. It wasn't concealed. It was a big 30 round on it. It wasn't concealed. But yeah, though, I had it on me.
Okay. Was it in a pocket or under a shirt or something?
No, it was outside. It was sticking out. It was hanging out.
Okay. Was it partially inside of a pocket?
No.
All right.
I had it out.
Mr. Howler, I don't know if you need to have a discussion, but we need to know whether it was concealed or not at some point.
That's what I'm saying. My shit wasn't concealed. That's what I'm saying. I don't even know why I'm going through this. My shit wasn't concealed. It was not concealed.
All right,
Now,
Mr.
let's
Howler.
prove it was concealed. I want to go to trial.
Hold on,
You're
Mr.
what?
Bailey. All right, Mr. Bailey.
My gun wasn't concealed. It wasn't concealed. And I'm sick y'all trying to do me like
That comment isn't just inappropriate, it's contempt adjacent. Judges have broad authority to sanction behavior that disrupts proceedings. Direct contempt can result in immediate custody. No jury. No delay. Just a judge exercising authority to preserve order. Notice how quickly the judge responds. Warning, correction, clear boundaries. That's a judge and not your bro. That statement matters. Courtrooms are hierarchical by design. Informality might feel natural on Zoom, but legally speaking, it's still a formal proceeding. The wild part? None of this had anything to do with the strength of the case. This is pure self-sabotage, behavior creating consequences where strategy should be guiding decisions.
All right, Mr. Bailey. Mr. Bailey, settle down. All right, Mr. Howard.
Man, this is wrong, man. Y'all do
Mr.
people
Bailey.
like this, man.
Mr. Bailey, just listen. I'm not going to accept the plea. I'll let you go forward to have a trial. Mr. Howley, you want the examination date?
Yes, I do.
All right, so Mr. Bailey, you're going to be going on. I'm not going to accept any pleas from you today, sir. If you're innocent, we're going to let you go forward and exercise your constitutional rights to have a trial. So we're going to the next stage. So the next stage is at a preliminary examination. Mr. Najer, as it relates to any offers.
Your Honor, it goes forward as a no reduce plea.
All right. So, Mr. Tooks, can I have examination track for Mr. Bailey?
Not a problem. It's going to be Judge Sabri.
All right, Mr. Holler, this matter is going on the examination track before the Honorable Judge Aaliyah Sabri for a Zoom PCC May 30th at 8:30 a.m. Again, before the Honorable Judge Aaliyah Sabri for a Zoom PCC May 30th, 8:30 a.m.
Okay. All right, thank you.
All right, Mr. Bailey, you going to the next stage, sir. You going forward to have a preliminary examination, sir. You got that date and time?
Yeah, because I ain't going out like that, man. I can't go out
That's
like
fine.
that, man.
That's fine, sir. You can exercise.
I can't go out like that. That my shit wasn't concealed, man. They trying to play me dirty.
All right, you can go forward, sir, and have a trial. Have a good day, sir.